Hello, everyone. Today's commentary is the second in a series of commentaries concerning the implementation of laws in Canada suppressing freedom of speech. It's called Natural Law, the Antidote to Tyranny. We begin with a quotation from St. Thomas Aquinas, who had a lot to say about the law. It reads, "Things that lack intelligence nevertheless act for an end. Whatever lacks intelligence cannot move towards an end unless directed by some being endowed with knowledge and intelligence. This being we call God." In a recent commentary entitled The Sounds of Silence, we addressed the specific threat posed by Bill C-9, the Combating Hate Act. It would be great if Bill C-9 were all we had to worry about, but sadly, it is but one piece of legislation in a suite of laws threatening to make Canada over into a fully totalitarian state. Tyranny rarely announces itself. It creeps through the pages of legislation, worded in comfort, sold as compassion, and hidden in committees, while we, the people, are too busy working, scrolling, or sleeping. 4 bills now sit before Parliament: C2, C8, C9, and the ghost of C63. Individually, they seem technical, procedural, bureaucratic, even dull. But taken together, they form the blueprint for a police state, one designed not to protect us, but to pre-approve our very existence. They call it safety, but we call it surveillance. The first blade comes dressed as an anti-money laundering measure. Bill C2 empowers Canada Post, when it operates, to open private letters, quote, in certain circumstances. It widens the cracks in our constitutionally protected expectation of privacy. Hidden deeper in this law is criminalization of all cash transactions over $10,000. It also restricts third-party deposits, effectively painting large cash transactions as so suspicious as to be presumptively criminal. Then comes the phrase that should make us all flinch. Quote, "Every electronic service provider shall facilitate authorized access to information as required by an act of Parliament." End quote. That one sentence could become the legal portal to your private data. Authorized access means without a search warrant. It means permission from some government bureaucrat appointed to do the government's bidding. Freedoms like privacy do not vanish overnight. Often, they are audited into extinction. Just as Bill C2 tightens the noose around our wallets, Bill C8 loops it around our throats to choke us into silence. Branded as the Cybersecurity and Critical Systems Protections Act, it grants the Minister of Public Safety the power to secretly order telecom providers to, quote, "do or refrain from doing anything," end quote, in the name of national security. That could mean destroying, blocking, or monitoring communications without any public disclosure. The same clause that protects networks can just as easily be used to silence our dissenting voices. Indeed, this is precisely how this power is being applied in such free states as Russia and China. Control the networks, and you control the narrative. The plug becomes mightier than the pen. Bill C9 wraps itself in the language of virtue signaling, but beneath its noble title lies a political weapon disguised as compassion. It criminalizes undefined hate symbols, expands the scope of hate-motivated offenses, and allows prosecution for acts of intimidation or obstruction around protected spaces. These are terms so broad as to capture protest signs, sermons, or satire. Billboard Chris and Babylon Bee, beware. The threat is not punishment of hatred. It is rather the definition of it by politicians, bureaucrats, and malevolent activists who already label dissent as extremism. In the name of tolerance, they are building the tools of tyranny. Bill C-63 is labeled the Online Harms Act. It died on the order paper earlier this year, but its ghost is still very much with us. It would firstly create a digital safety commission to regulate online speech. Secondly, rearm the Canadian Human Rights Commission to prosecute offensive online expression. Thirdly, impose civil penalties up to $50,000 for non-criminal speech. And fourth, introduce a pre-crime recognizance, allowing courts to restrict us based upon the mere suspicion that we might commit a future hate crime. Just imagine being bound by a restraining order because of what someone thinks you might someday say or do. This is not how a free and democratic society is governed. It is predictive tyranny. Though shelved for now, insiders say that C63 is being reworked for quiet reintroduction under a more innocuous name and softer branding. The pattern we see emerging across these four laws is unmistakable. Each is a brick in the wall between us and the state. Together, they form the legislative skeleton of a soft totalitarianism. And we've seen this picture before. In 1970, Pierre Trudeau invoked the War Measures Act, suspending civil liberties in the name of national security. In the US, the Patriot Act was passed in the wake of 9/11. It turned temporary emergency powers into a permanent surveillance regime that was exposed by notorious whistleblower Edward Snowden. In East Germany, the Stasi justified every intrusion as protection from extremism. All tyranny throughout recorded history has been built upon the scaffolding of safety. The only difference today is that with modern technology, it is faster, quieter, and total. By Christmas, these bills could move silently through committee, signed, sealed, and forgotten by an increasingly exhausted public. And when the enforcement begins, it will not look like dictatorship. It will instead look like policy: a fine here, a warning there, a deleted post, a frozen bank transfer, a flagged parcel. No handcuffs necessary, just compliance through fear, based upon the new state enforced religion of power. These bills are proof that empires now build programs instead of cathedrals. The altar of the new secular church is the committee table. Its scripture is regulation. In Mark Carney's Canada, faith has become the newest instrument of policy, a language of inclusion weaponized for control. Carney's ministers speak of compassion, of reconciliation, and multi faith partnership. But beneath these hymns of harmony lies an age old ambition to make every creed serve the state. This is not a war on religion, it is a war through religion. A government using the very symbols of virtue to sanctify enforced obedience with state diktats. In the name of diversity, new agencies fund religious and cultural councils tasked with building community trust. In practice, they become arms of the administrative state. Liaison boards translating Ottawa's evil agenda into moral, sterile, gender neutral language, always sending the same message: trust in the state, for it shall protect your conscience, so long as your conscience never contradicts state policy. Carney's technocrats have discovered that control through compassion is cleaner than coercion. After all, why police a people when you can simply persuade them that surveillance is empathy? Why argue with conscience when it could be bought? Thus, the grants, the roundtables, the programs, each one framed as service, each one binding communities to bureaucracy through funding and the fear of losing it. Equality is replaced by managed inclusion, the idea that we must prove ourselves to be safe participants in a state defined, limited democracy. Faith becomes branding, worship becomes partnership, and secular morality becomes a stakeholder. Under the banner of respect for difference, the government flirts again with faith based arbitration and community social justice models. These are not the revival of belief, they are rather the outsourcing of authority. The state does not surrender power, it redistributes it to committees owing them fealty. The result is a divided people under a single administrative secular creed. Carney preaches equilibrium rather than truth. His is the gospel of managed consent, rules flexible enough to not offend any ideology, and regulations firm enough to bind everyone. In this theology of governance, there are no sinners, only stakeholders, all of whom must tithe to the system. Global compacts replace scripture. Sustainability metrics supplant Christian morality. Virtue is measured in compliance. Those of us who choose to live by conviction now stand in the margins. Christian teachers disciplined for refusing to recite ideological pledges. Parents investigated as extremists for questioning leftist curricula. Faith groups threatened with defunding for their public dissent. They were all promised inclusion, but handed assimilation. They were promised a voice, but fed talking points. The tragedy is not that faith was betrayed, but that it was retooled into a delivery system for political virtue signaling. Very soon, new, quote, community engagement directives will roll out in Canada, each one pairing moral language with legal power. They will say equity, but mean enforcement. They will say dialogue, but mean data collection. They will say trust, but mean tracking. When resistance rises, Carney's purchased press will label it extremism. The modern state no longer burns heretics. It simply reclassifies and banishes them from participation in society. Our fight is then not against faith, nor culture, nor conscience. It is against the government, which exploits all of them. Religious freedom was enshrined in our law to defend belief from the state, not to permit the state to weaponize belief itself. There can be no freedom when morality flows downward from a bureaucrat's desk. We must reclaim our conscience. We must reclaim our communities. Most of all, we must reclaim our natural law. Modern political discourse is wholly devoid of such lofty and intellectually honest concepts as natural law. It is instead hyper-focused upon discussing rights without even the slightest attempt to apply a philosophical context to them. The slow and steady degradation of liberty that we have seen in this country stems directly from an increasingly lost understanding of natural law and how it guides and informs our interaction with any human government. If we reclaim that understanding, intentionally interject it into conversations about government, and faithfully make personal choices consistent with it, then freedom-loving Canadians may yet push the pendulum of social change back to what our nation was meant to be, a haven for the immutable reality of God's gift of human liberty. Natural law is part of what we might call the second tier of first principles. It is a logical extension of the ultimate first principle of God as creator. In his prolific writings on natural law, Lysander Spooner argues that natural law is universal for all time and in all places because it is part of the fabric of creation as much as the phenomena of light or magnetism are, and as such can be studied, learned, and discerned in the same way we can scientifically contemplate gravity. Spooner therefore calls this the science of justice. It is second tier since, as a law, it begs the question of a lawgiver, which is the true first principle. But functionally, for us today, it can still operate as a more focused starting point, guiding our actions and theories about how human governments like the Carney Liberals ought to operate. If we were huddled in a darkened corner of a local tavern with a group of friends 2 centuries ago, and our conversation turned to politics, then odds are that one or all of us would at some point appeal to natural law to decry tyranny and justify resistance. Natural law was baked into the common vernacular back then, and thus our claims to free speech, the bearing of arms, expression of religion, etc., were all logical conclusions drawn from natural law and then translated into constitutional law. What then is natural law anyway? Well, in his essay entitled Natural Law, the Science of Justice, Spooner describes natural law thusly. Quote, "The science of mine and thine, the science of justice, is the science of all human rights, for all a man's rights of person and property, of all his rights to life, liberty, and the pursuit of happiness. It is the science which alone can tell any man what he can and cannot do, what he can and cannot have, what he can and cannot say, with infringing the rights of any other person, It is the science of peace, and the only science of peace, since it is the science which alone can tell us on what conditions mankind can live in peace or ought to live in peace with each other. End quote. Spooner then goes on to describe the conditions under which mankind can live in peace with each other. Quote, these conditions are simply these. First, that each man shall do towards every other all that justice requires him to do, as, for example, that he shall pay his debts, that he shall return borrowed or stolen property to its owner, and that he shall make reparation for any injury he may have done to the person or property of another. The second condition is that each man shall abstain from doing to another anything which justice forbids him to do, as, for example, that he shall abstain from committing theft or robbery, arson, murder, or any other crime against the person or property of another. End quote. Now, most of us are familiar with the liberal maxim, quote, my rights stop where yours begin, end quote. It should thus make sense to us that natural law is the science of mine and thine, and the science of peace. It recognizes basic property rights. It also explains the means and the purpose for which those rights are to be secured: peace rather than war. It is worth noting here that Spooner draws a clear distinction between what is legal and what is moral. The legal pertains to property rights, informed by natural law, and the moral pertains to ethical considerations of social relationships. This distinction between legal and moral is a vital one for outlining the prerogative of human governments, like the Carney Liberals. Much of our current legal morass in Canada is rooted in a fundamental misunderstanding of this distinction, which is often intentional. In the case of the Carney Liberals and its suite of speech restriction laws, for example, we see the government wading into the sphere of the moral, when it ought to be confined to the legal. Such usurpations of personal liberty are akin to a Christian baker being forced to create a cake for LGBTQ customers, thereby infringing upon the legal right of property over his time and resources, depriving his freedom of association, which he exercises based upon his moral principles. A legal system exists because there is such a thing as legal, and since mankind is fallen, there will always be a need for arbitration of some kind. Both morality and legality are issues adjudicated in a court, but whereas a legal issue might play out in a well-defined system with a prescribed means of enforcing justice, a moral issue plays out in the court of public opinion, where justice is defined more on a social level. A man may operate fully within his legal rights, but be marked as unethical for certain actions and face repercussions like social ostracism, as his community deems necessary until sufficient retribution is exacted. Borrowing the example of the baker, if he set up a shop in a predominantly homosexual community and insisted upon refusing service to them, then he is unlikely to survive in business for very long. So, what then are the fundamental legal rights of a man under natural law, according to Spooner? First, to be dealt with honestly. Secondly, to not be intentionally and unjustly hurt. And third, to be given what he is due. Spooner expresses these rights also as duties, since he argues that justice is a reciprocal phenomenon. By virtue of claiming these rights for ourselves, we must therefore honor them in others. Quote, the ancient maxim makes the sum of a man's legal duty to his fellow men to be simply this: to live honestly, to hurt no one, and to give everyone his due. End quote. Framing them as duties will eventually provide us with the case for the institution of a government of some sort. But a strict adherence to the natural law prompted by a people who think in those terms, provides solid guardrails, offering the best hope for staving off the tyranny that comes as a feature of every other political system throughout human history. So, how do we know that natural law exists? Well, C.S. Lewis, in his seminal book, Mere Christianity, posits as evidence for the existence of God the fact that mankind, throughout all cultures and all history, has always worshiped something. This deductive logic works backwards from an observed phenomenon to find the simplest explanation. It is also exactly what Spooner applied 65 years earlier in his own writings. We can know that justice exists, and therefore natural law, because we all expect it to be so, and frankly, need it to be so if we desire peace. We observe that all cultures throughout history have some elemental understanding of basic expectations for how to live peacefully with one another. That we fail so often to do so is not an argument against the principle, any more than an atheist, deluded by his own faulty logic, is evidence that there is no God. That we fail on a spectacularly grand scale, such as we see today, is also not an argument against the principle. Spooner further demonstrates that children learn justice long before they even understand the words used to describe it, and that they can learn it completely independent of external instruction. How, you ask? Quote, children very early understand that one child must not, without just cause, strike or otherwise hurt another. That one child must not assume any arbitrary control or domination over another. That one child must not, either by force, deceit, or stealth, obtain possession of anything that belongs to another. That if one child commits any of these wrongs against another, it is not only the right of the injured child to resist, and if need be, punish the wrongdoer and compel him to make reparation, but that it is also the right and the moral duty of all other children and all other persons to assist the injured party in defending his rights and redressing his wrongs. These are fundamental principles of natural law which govern the most important transactions of man with man. Yet, children learn them earlier than they learn that 3 and 3 are 6, or 5 and 5 10. Their childish plays, even, could not be carried on without a constant regard to them, and it is equally impossible for persons of any age to live together in peace on any other conditions. End quote. Children learn these truths not as concepts, but as real world realities. They learn that unless they want a bloody lip or be terrified to leave the safety of their house, they must behave in a manner producing maximal peace and the most fun on a summer afternoon in the neighborhood. Good parents reinforce this learned behavior by modeling it in their own lives and also via overt instruction. Quote, in truth, it would be impossible to make them understand the real meanings of the words if they did not first understand the nature of the thing itself. To make them understand the meanings for the words justice and injustice before knowing the nature of the things themselves would be to make them understand the meanings of the words heat and cold, wet and dry, light and darkness, white and black, one and two, before knowing the nature of the things themselves. Men necessarily must know sentiments and ideas, no less than material things, before they can know the meanings of the words by which we describe them. End quote. This observation aligns with the words of the Apostle Paul in his letter to the Romans. Paul explains that the natural man, even without knowing the personal revelation of God through his prophets, or in the person of Jesus Christ, is able to be held to account for violating God's law because we know it inherently, but are incapable of obeying it perfectly. Paul writes in Romans chapter 2, verses 14 to 16, quote, for when Gentiles, who do not have the law, by nature do what the law requires, they are a law to themselves, even though they do not have the law. They show that the work of the law is written on their hearts, while their conscience also bears witness, and their conflicting thoughts accuse or even excuse them on that day when, according to my gospel, God judges the secrets of men by Christ Jesus. End quote. But even apart from observing natural codes of justice forming among children or appealing to scripture, Spooner observes by logic that the principle of natural justice must exist. Quote, if it be not a natural principle, all the appeals for justice that have ever been heard and all the struggles for justice that have ever been witnessed have been appeals and struggles for a mere fantasy, a vagary of the imagination, and not for a reality. End quote. Expounding upon this, he points to the type of social justice that the Carney government is attempting to achieve by legislating an artificial, secular form of morality. Quote, if justice be not a natural principle, then there is no such thing as injustice, and all the crimes of which the world has been the scene have been no crimes at all, but only simple events like the falling of the rain or the setting of the sun, events of which the victims had no more reason to complain than they had to complain for the running of the streams or the growth of vegetation. End quote. Those are the first two of 15 if-then propositions Spooner makes to thoroughly establish both the existence and very nature of justice. Being a part of nature itself, justice is therefore immutable and, quote, can no more be changed by any power inferior to that which established it than can the law of gravitation, the laws of light, the principles of mathematics, or any other natural law or principle whatever. And all attempts or assumptions on the part of any man or body of men, whether calling themselves governments or by another name, to set up their own commands, wills, pleasure, or discretion in the place of justice as a rule of conduct for any human being are as much an absurdity, a usurpation, and a tyranny as would be their attempts to set up their own commands, wills, pleasure, or discretion in the place of any and all physical, mental, and moral laws of the universe. End quote. Spooner concludes that if the principle of justice does not exist, then there is no basis for any sort of moral code, and the world is reduced to an, quote, abyss of moral darkness, end quote, which rather describes what living in Canada feels like today for conscientious Christians who still cherish liberty, justice, and truth. For us, there must be a principle of justice, which we can refer to as natural law, and through application of logic, we can easily discern its properties. Rather than an abyss of moral darkness, which the Carney liberals are creating through heinous legislation, we Christians have the basis for optimism. Because just as we have harnessed natural forces to fuel technological advances, we can also harness natural law to coordinate our societal progress. And this is not an exercise in utopian daydreaming. There will always be usurpations like the ones being perpetrated now by the Carney government. But knowing what eternal resources are at our disposal is half the battle. Anyone paying attention to what is happening in Canada, and indeed globally today, will recognize that we are in a moment of weighty resolve. We can cast off tyranny and attempt to improve the human condition and use natural law principles to write our own new chapter in the historical events of liberty. This new chapter may well be framed as the Golden Age, but it will quickly lose its luster if we fail to reclaim our rights under natural law, which is God's eternal law for mankind. With the information war as the backdrop, it is therefore my fervent prayer that we will return to the forefront the language of debate based upon acceptance of transcendent truth as the basis for our law and morality. It is the only proven antidote to the tyranny of power-hungry governments. We end with a quotation from Thomas Aquinas, which reads, "Law is an ordination of reason by the proper authority for the common good and promulgated."